Good day, Hurera. How are you?
I'm fine.
What are you reading today?
I'm reading a judgment. It is regarding labor laws and trade union within an industry.
Okay, please tell us what this case is.
Okay, the citation of the judgment is 2024 SCMR 1148.
Okay,
Brief facts of the case are that some of the respondents were brought through an independent contract by a company from the other three companies. As those employees were working in the company, they were willing to join its trade union to avail its benefits, but they were refused by the company solely on the ground that they are not the permanent employees of the company. That means they have been brought through an independent contract. The matter went before National Industrial Relations Commission and they made a findings in favor of those employees who were working in the company, allowing them to join a trade union and directing the company not to make any sort of obstacle in way of joining process. The matter was then appealed before High Court and they affirmed the findings of National Industrial Relations Commission. Now the matter was appealed before Supreme Court. The legal question before the Supreme Court was who actually employed those employees, whether it's a company in which they are working or a contractor who has sent them to work in the company. To answer this, the Supreme Court looked into the employment agreement to figure out from how long those employees were working in the company. As those employees were working in the company from last many years without any gap, they were taking salaries from the company bank account, they were making their attendance to the company, they were directly or indirectly connected with the manufacturing process of the company. That means they were under direct supervision of the company. While the Supreme Court reiterated the same view as laid down in its previous judgment, where it was held that a company cannot be allowed to describe outsourced employee to fraud with the labor laws under the pretext of sham agreement. Hence, this appeal was again dismissed and those employees were allowed to join a trade union of the company in which they were working.
I see.